So I'm asked occasionally, why do I need a will? And in some cases, individuals do not need a will. If they've set up their estate in such a manner that they've put their children on as beneficiaries, or if they've established joint accounts with their children or put them on the title and they want their children to have it, you may not need a will. If you are okay with how the law says your assets are to be disposed of, so if you just have 3 children and don't have a spouse, that the law says it goes to the 3 children, you might be okay with not having a will. However, lots of people need the wills. And a lot of people need the wills regardless of whether they have any assets. So let's talk about the situation of the young family members that walk into my office and say, what do we need? And they need a will for different reasons than maybe assets. And they do need, because they may not have a lot of assets, but they need a will because they want to do 2 things. They want to, first of all, determine where their assets go, and so to the extent that they die, they probably want the assets to go to each other. They also want to make sure that it goes to the children, but if they have young children, they want to establish a trust for the benefit of those children. They don't want those assets to go to the children directly. Actually, if the children are 18, they don't go directly. They would go to a guardianship account, monitored account in surrogate court, which is not exactly the most efficient way to handle things. But a trust is established for the children that has the terms of the trust, determines how long the trust will last, and then, more importantly, names individuals who will be in charge. So there's 3 groups of people when you do a will that you have to think about who's going to be in charge of various aspects of your late life. Number 1 is you have an executor. The executor deals with the estate. And kind of a short-term job. It kind of picks up your assets, pays your bills, and distributes the way you said you're going to distribute it. Now, obviously, for most people, husband and wife, it's going to go to between husband and wife. But then you're going to have an alternate if you're both gone. Now, in the case of the kids, that executor is going to turn the assets, whatever's left, over to the trustee, which is kind of a long-running job. Because if you have young kids and the trust is going to go till 21, these are people who are going to handle the assets of your assets for years and years and years, potentially, to fund the kids' education and all kinds of things that the kids need. Then finally, you want a guardian for the actual who will have those kids for as long as the kids remain, usually 18 is the date they have majority. But you want to name the kids. Now, many people, when they look at their families, can only come up with a couple people that they'll trust their kids and their money with. So a lot of times the guardian, the trust, and the successor executor or trustee they're all the same people. However, there's no reason they have to be the same. I mean, there might be children that are people that are good with children, they can have the kids. People good with money, they can have the money. I always caution people, though, and sometimes you have to do this, but be careful about naming your parents as the guardian. As a grandparent of a 3-year-old, I mean, as much as I think this is a wonderful kid, I'm not sure I want to take care of her when she's 16 and I'm 78. So you always have to be thinking about that in relation to who you're going to appoint. Very important but speaking of the laws of administration and the laws that the law sets up if you don't have a will, one should always remember that if you have a spouse and children, the law doesn't give all your assets to your spouse. The law says the spouse gets the first $50,000 and 50% of your assets get divided between the spouse and the children. This sometimes causes a lot of problems, particularly if there's an expensive house in the deceased's name alone. So it's good you have just a basic will that says, I give everything to my spouse. That's not a bad idea. So there's various reasons to do that. The other issue in wills is, unfortunately, there comes a time a lot of people leave people out of wills. Spouses, children, families have different relationships, and unfortunately, you'll see that someone will say as well, I want to give it to the 4 kids, but I don't want to give it to my 5th. We always want to make that clear in the will that's why. You don't need a reason to do that, but if you need to do it, that's something you need to put in a will.